The evidence question from February of 1998 is quite interesting. It's a hybrid format. On its face, it looks rather like a transcript problem. But actually, we're just given a chronology, and then at the end we get something that's pretty much standard, a basic evidence essay problem. Have a look at the material in bold and the call of the question. First, let's have a look at the call of the question. Assuming all appropriate objections were made, should the court admit the evidence offered by the prosecution in numbers 13, 14, 15, and 17 as specified above? Discuss. Fair enough. Let's have a look at those items above. In item 13, the prosecution seeks to introduce the certified transcript of the preliminary hearing testimony of Detective Phillips. It appears to be presenting a former testimony issue. We're going to have to examine the facts to see if we admit the transcript or not. In item 14, the prosecution is calling Bernice, seeking to have her testify as to two different confessions Don allegedly made, and both Bernice and Don raise marital privilege objections. Well, we've got two different dates. We're going to have to look carefully at that. Assuming these two were married before August 1, neither one of these convictions should be admissible. Number 15. Next, the prosecution calls witness seeking testimony as to Victor's reputation for peacefulness in the community. Reputation evidence probably is okay, but specific acts evidence, as you know, is somewhat more problematic. Then, in item 17, Don testifies in his own defense, and on cross-examination, the prosecution seeks to impeach Don with a 1985 bribery conviction. Well, we know that's more than 10 years old, so I suppose we're likely to be somewhat hostile to this item of evidence. But again, we're going to have to take a careful look at the facts and reevaluate accordingly. So now let's go to the top of the problem, and let's briefly skim the chronology of events. We see that Don is being criminally prosecuted for armed assault against the victim. And so we've got 12 items in the chronology before the remaining 5, of which 4 are at issue. So first, Don is convicted of bribery back in 1985. We knew that. June 1, 97, the assault that the criminal trial is all about. June 4, 97, we've got a lineup identification. June 6, Don is arrested and charged with assault. August 1, Don confessed to his fiancée that he's the one who assaulted Victor. Okay? This confession happens before the marriage, and so it isn't covered by the marital privilege, no matter how we interpret it. The marital privilege only covers communications that occur during marriage. Next, item 6, Detective Phillips testifies at the preliminary hearing that Victor identified Don, and Phillips was cross-examined. Okay? That covers some of the requirements for admitting former testimony. We need to find that this witness is unavailable in order to complete that circle. On September 1, the defendant and Bernice are married, and so the subsequent confession is not going to be admissible based on the marital communications privilege. Next, Detective Phillips is shot and killed in a hunting accident on September 15, 1997. That completes the circle, and he's unavailable. Next, on October 1, a second confession, inadmissible. On November 1, 97, Don and the wife are divorced, a pretty short marriage. Now, the case against Don comes to trial, and then Victor testifies at trial. He remembers making a lineup ID, but he can't make an in-court identification. No wonder the prosecution wants this certified transcript to come in. Next, we get the items in bold type and then the call of the question. So, please turn to my outline of issues, and here, once again, you'll see that going into a lot of detail during organization can make writing a lot easier than it would be otherwise. Here we've got an example of an outline that might actually come close to being a serviceable answer to the problem. Obviously, we want to give plenty of analysis, but I think you can see that this outline spots the issues and resolves them with a fair amount of detail, just superficially. So we focus on the certified transcript. It is relevant because it is evidence of the defendant's guilt. We've got authentication and best evidence issues, but since the transcript is certified, those probably are not a big deal. Next, we focus on the double hearsay situation, the statement made by Victor and then the testimony of the detective. It seems as if ultimately we're going to overcome the double hearsay problem and the right to confront will be satisfied as well. So we're going to admit this testimony. Next, we turn to Bernice's testimony about the two confessions. It's relevant because, again, it proves that the defendant is guilty. The first objection is hearsay. An admission certainly is non-hearsay under the federal rules, and it's an exception everywhere else. Next, we've got the marital privilege objection, and we focus on the dates. Ultimately, we admit the earlier of the two confessions. The third item we need to discuss is Victor's reputation for peacefulness. It is relevant, again, because it supports the prosecution. We've got an objection based on improper character evidence and a novel conclusion. Perhaps it's inadmissible in the prosecution's case in chief. If the defense brings the victim's character into question, then the prosecution would be able to get this evidence in. A close reading changes our mind from our earlier impression based only on the call of the question. Then, finally, we focus on the bribery conviction. I think that it is somewhat dicey to establish relevance, but the objections include character evidence and the chance that this testimony might be more prejudicial than probative. In the end, I conclude that it's such a close call that the judge can make a decision either way without abusing his or her discretion. So, we see that the fewer the number of items of evidence at issue, the greater the depth of our analysis. We compare this answer with only 4 items being discussed to one of the transcript questions, which requires us to talk about 7 or 8 or even 9 items of evidence. And obviously, those are a lot more superficial. Those are much more a series of quick, short answers than the analysis that we present in our answer to this question. But you'll see, I use this outline as the superstructure of my answer, and I think you'll agree, this is an answer that's easy to skim, easy to read, and therefore reader-friendly. Let's have a look at it. On page 1 of the answer, I focus on the transcript and I go into relevance. Notice how I lead with the facts and I explain specifically why this evidence is relevant. The victim can't make an in-court ID, and therefore the transcript is extremely important to the prosecution's case. Then we focus on authentication and best evidence, and we write it off in just a couple of lines because the testimony is certified. The core problem with this transcript is the double hearsay issue, and you'll see that I work in a very concise definition of hearsay right into the lead-in under item C. Then we focus on each statement. The statement by Victor is non-hearsay because it is a prior identification. The testimony of Detective Phillips will be admissible if it satisfies the requirements for admitting former testimony. First, the detective was under oath. Second, he's unavailable because he's dead. And third, the defendant was previously able to cross-examine this witness. So the certified transcript is admissible. And if you're not sharp on this past testimony material, this fact pattern gives you a golden opportunity to get about as sharp as you can hope to be on this topic. Of course, the multi-state is going to take care of this little item of business as well. Next, we turn to an objection based on the Sixth Amendment right to confront. I toss that off very briefly, and I conclude that the transcript comes in. Next, we go to the confessions. This is pretty simple stuff, in my opinion, and it also is consistent with the way this issue is tested on the MBE. The relevance of the testimony is almost self-evident. These confessions prove the guilt of the defendant. The lead objection is hearsay. It comes first. They are non-hearsay as an admission in the federal courts and an exception elsewhere. I focus on the marital privilege objection, which is really the core of this item's analysis. Here, both spouses have a privilege that they can assert, and both of them are raising their privilege. But the problem is the earlier confession didn't occur during the marriage, and so it doesn't rate a marital communications privilege claim. So the August 1 confession comes in. Next, we turn to the reputation of the victim for peacefulness. It appears to be relevant because, again, it would support the prosecution's theory. But the problem is the defense has not brought the victim's peacefulness into issue. There's nothing about the character of the victim that is present here. The defendant doesn't claim to have acted in self-defense, and so we've got a problem right up front with relevance. But next, we focus on the character evidence issue, perhaps the most complicated issue from evidence that regularly is tested, and here the victim's reputation isn't at issue, certainly not at the point of the prosecution's case in chief, so the people aren't going to be allowed to bring this evidence in. Finally, we focus on the bribery conviction. And here we've got the prosecution seeking to impeach the defendant who is testifying on his own behalf with cross-examination questions, or at least one question about this bribery conviction. Obviously, it would tend to throw doubt on the credibility of the witness, and he's already been convicted of bribery. But there's obviously a character evidence objection here. The 10-year rule would allow it in. Beyond 10 years, we have to rely on judicial discretion. It seems to me that a pretty good argument can be made that this evidence would be more prejudicial than probative, and if I actually had to make the decision, I don't think I'd let this conviction in. But based on what we know about the problem, I can't say it would be an abuse of discretion for the judge to decide either way. And that concludes a discussion of this rather interesting hybrid evidence problem. Since it isn't a transcript problem on its face, I guess we have to throw it in with all of the other standard evidence problems. Only 4 items were tested, and thus we had to go into quite a bit more depth for each one of them.